Welcome back to Noka Media, your source for Northern Ontario homegrown media content.
And by exactly 1 minute, according to my phone. So we'll just get ourselves started here. So I'm with the Sudbury Community Legal Clinic. We are a non-profit organization that serves Sudbury, Greater Sudbury, and the District of Sudbury, which includes Chapleau and all sorts of other places. And we provide free public legal education, so telling people about their rights like we're doing today. And we also can help low-income people if they're having issues with landlord-tenant or with social benefits, such as, they've suddenly said to you, hey, your CPP, we paid you too much, you need to give us some of it back, and you thought that was unfair. That could be an area that we might be able to help you out in. ODSP, all of those other kinds of things. And we also do wills and powers of attorneys with people across Northern Ontario. So Megan's program is a specialty program that allows assistance for seniors 55 and older, 60 and older to get free service in wills and power of attorneys. And then we also have the specialty program that I run, which is sexual harassment in the workplace, but today we'll be looking at sort of workplace law in general. And then I also work with the Sudbury Workers Education and Advocacy Center. We also serve throughout Northeastern Ontario, and we do similar things, only we don't provide legal representation. We just provide client navigation and community support to people. So one way or another, I can always help people with workplace law questions. And before I go any further, I forgot to actually look up the territory we're in here. I know there are several Anishinaabe First Nation communities here. I come from Sudbury, which is the traditional territories of the Atikameksheng Anishinaabe and Wahnapitae First Nations. I believe most of the First Nations here are signatories to the Robinson-Huron Treaty. It's always important to recognize, the reason I think it's important for me to do this today is it's important to recognize that, different countries have different laws, different provinces have different laws. We're going to be talking about the laws in Ontario for employment. And the First Nations people that came before us had different laws as well. And in some cases, we've created legal agreements with those people, the Robinson-Huron Treaty, and in other cases that we haven't. And it's important to recognize that, we as a nation need to continue to honor the agreements that we've come up with people in all times, just like we would want people to be honoring, you agreed to build this fence for me, you agreed to do this work for me, whatever it is, right? Just a reminder that, the relationship with our First Nations people is many things, cultural, but it's also a legal relationship and one that needs to be discussed and reminded of. Today, I'm just giving you legal information. I won't be providing you with legal advice. Nothing I say today constitutes legal advice. The information is current as of yesterday. There's been no changes to the law since today, so it's also current as of today. And if you do want to ask questions, I'm going to ask you to please try and ask those questions in a sort of anonymous way. So don't specifically say the name of your employer, don't specifically say the name of your supervisor, your coworker. Just sort of ask in a general way, so that nobody's revealing any confidential information. And it might be better as well, at a certain point, it might be just like, hey, it sounds like you've got a specific need, let me chat with you at the end of the presentation around that. So today we're just gonna race through a whole bunch of stuff. You can stop me and ask questions anytime, but we're gonna sort of look at how are workplace rights protected. We're gonna talk about who actually is a worker, because some people aren't workers. They might be independent contractors, they might be something else. We're going to look at your basic rights under the Employment Standards Act, wages, deductions, hours, scheduling breaks, overtime, vacations, and holidays. We're going to talk about leaves. We're going to talk about termination. And even though it's not the Employment Standards Act, we're going to briefly touch on harassment, violence, and sexual harassment and discrimination, and talk about filing claims. That's a lot to cover, so let's just keep motoring through. So how are rights protected? As we know, Canada is a federal country. Most rights in the workplace are regulated at the provincial level, so by and large, work is considered to be a matter of responsibility for the provincial governments. However, if you work directly for the federal government or a crown corporation of the federal government, such as the National Arts Centre or something like that, you are covered by the Canada Labour Code. And then certain sectors, those that cross provincial lines, such as banks, transportation, if it's interprovincial or international transportation, is covered by the Canada Labour Code as opposed to provincial codes. Postal and courier services, including Canada Post, telecommunications, so Rogers, Eastlink, all of your cable providers, and then energy, when we're talking about like energy that goes again across provincial borders and boundaries, is regulated at the federal level. I can provide answers to any questions you have about the Canada Labour Code, but that's not the focus of today's presentation, because the majority of people are provincial. We're going to be looking at it in a provincial way. And the workplace legislation that covers your rights at work, first and foremost, is the Human Rights Code of Ontario. Much like the Charter of Rights and Freedoms at the federal level, it's sort of the overall law that governs everything. Everything has to be to conform to the Human Rights Code of Ontario. And then specifically, we have the Employment Standards Act, the Occupational Health and Safety Act, the Workplace Safety and Insurance Act, which gives us the WSIB for injured workers, the Pay Equity Act, the Ontario Labour Relations Act, which talks about how unions are formed and have to govern themselves. And then there's also the Personal Information Protection and Electronic Documents Act, which is a federal act, but sort of governs your rights to privacy. There's no provincial privacy rules except for healthcare and government in terms of like private businesses. There's a few other acts as well, because there's the Law Society Act, the Teachers and Educational Professionals Act. There's a couple of other specific acts that deal with specific things, but we're not going to go into those. So, who is a worker? Lots of people work, but are you actually a worker? So when we're talking about a worker, an employee, we're talking about somebody who has a boss. Their boss sets their wages, they set their hours, they decide the work that you do, and ultimately, you're a worker because income tax, employment insurance, and CPP are all taken off your paycheck by your boss, right? You can also be an independent contractor. You're your own boss, right? And an independent contractor, that means you set your own wages, which doesn't mean you don't think about, well, what is everybody else charging? Do I want to charge higher than everybody else because I do the job better? Do I want to charge lower so I get more work? Do I want to be right in the middle? You set your own hours. Again, you might decide with your client, all right, you don't want anybody working on your bathroom before 8 a.m. and after 6 p.m. I get it. I'll try and do all my work within those hours. And then ultimately you decide what work you do. Lots of times though, your boss will try and pretend that you're an independent contractor when you're not actually your own boss, right? They actually set your wages. They tell you the hours that you have to work, and they tell you exactly the work that you're going to be doing. You don't actually have any choice of that. So you're not really an independent contractor. You may be misclassified. We'll talk about that a little bit more. You might be a temp agency worker. That means you work for Megan's awesome workforce. And Megan then sends people out to help Robert do the work in your workplace, or Mike in your workplace. You're like, oh, I'm short staffed. I'm going to contact Megan. I'm going to give Megan $500. She's going to send me some workers who are going to do work for me up to the amount. So Megan's actually the boss. Megan's your employer, but the worker actually works at Mike's workplace or Robert's Workplace or wherever it is, and that can create some special problems for workers. You could be what's called a digital platform worker. You work for a company through an app, mostly as a delivery driver or something like that. And Ontario has actually taken workplace rights away from you, and we'll talk about that later. And you could also be a co-op student or an intern in a workplace. Legally, to be an intern or a co-op placement student, you have to be registered with an accredited program, either through a provincial, or sorry, a public institution or a private college that's registered with the province, and you're doing a placement in order to graduate, right? So you're not getting paid, but you are being asked to graduate. Otherwise, there's no unpaid internships in Ontario. So, have you been misclassified? Is your boss trying to tell you that you're your own boss, even though you don't feel like your own boss? So there isn't any one test in law, but the basic questions that you have to ask yourself are, do you set your own wage rates, or is your boss telling you how much you're getting, right? Are you saying to your boss, yes, I will do this electrical work for you, I get paid $75 an hour? Or is your boss saying, I got a bunch of electrical work, I'll give you $50 an hour, don't even ask for more, right? Are you setting your own hours, or do you have to work when the boss tells you? Do you bring your own tools to the job, or is the boss providing all of the tools for you? Can you make a profit if you keep your expenses low, or do the work faster, or other factors that allow you to actually, make more money? So if I say to you, I'll build your fence for you, it's going to cost you $2,000, and I can get a really excellent, price on the wood, and I've got a whole bunch of leftover concrete for putting the poles in from another job that I did where they paid for too much, then I'm going to make some extra money, right? Then I'm going to make a profit. But if I actually screw up and I put it on the wrong line and I have to tear it down and put it up again, I'm actually going to lose money, right? So if I have the risk of making profit or losing, then I'm an independent contractor. If it's just like, it doesn't matter what happens, I'm going to get paid no matter what, I'm probably an employee. So those are questions to ask. If you have been misclassified, you can pursue an action through the Ministry of Labor, and the Ministry of Labor will help determine whether or not you are actually a worker or your own boss. If you are legitimately your own boss, and you were legitimately your own boss, as we were talking about yesterday, then it's not a matter for the Ministry of Labor, it's a matter for the courts, the civil courts, small claims or superior court, depending on how much you're asking for. So that brings us to the idea of contract. So not every employer, or every worker is going to be asked to sign a contract, right? McDonald's isn't asking, the 16-year-old to sign a contract when they come to work. Your fancy software company probably is asking you to sign a contract, right? So not everybody's asked to sign a contract. The important things to check if you know about signing a contract is you should be getting it in advance. It shouldn't be given to you on the day of signing. Or what we commonly see at the Worker Center is you've already done the work for 2 weeks, and now your boss comes up to you and he's like, hey, I'm gonna need you to sign this if you want me to pay, right? Like if I don't have a signed contract, I can't actually schedule your payroll. So just sign this right now. You don't need to read it. It's not important. It's a standard contract. Just, sign it or you're not getting paid. That's usually a pretty big red flag that they're trying to force you into signing something that isn't going to be good. You always have the right, if you're given a contract or any other document in the workplace, a confidentiality agreement, a disciplinary report or action, right? You have the right to get a copy of that, to take it home, to have it reviewed by a third party, including a lawyer or a paralegal, and to ask questions, potentially try and negotiate terms or things like that. You should never feel pressured into signing the contract. And big red flags are, does the contract call you an independent contractor when you think you're just going to be working for somebody else? Does the contract have a clause saying that they can change the contract at any time without consulting you? that's a big red flag. But the contract is supposed to be, you and I have agreed that this is going to be the conditions of what we do. We've had a meeting of minds. We are in agreement that what we've written down here is what we're going to do. If part of that agreement is, actually, I can change my mind at any time and just make it different for you, that's kind of a problem contract, right? Why is that fair? It means we haven't really agreed on everything, right? Like we're agreeing, but you're going to change your mind and I just have to take it? That's not agreement. Does it have what's called a non-compete agreement that would say you could never do similar work for somebody else after you're done with us? Any questions about contracts? Excellent. You can always ask questions. Digital platforms workers. So anybody who provides rideshare, delivery, or courier services for payment and are offered work assignments through an online digital platform such as Uber, Uber Eats, Skip the Dishes, a whole bunch of other ones, right? Digital workers are generally commonly misclassified as independent contractors, but the reality is you don't set your wages. The app tells you how much money you're getting for those jobs, right? You have no control over how much you're getting. Sure, there's the pretense that like, oh, you can just work when you want, except no, you can't. Like you either do the blocks that the app assigns you or the app stops assigning you blocks to work in, right? Like you either agree to work the shifts or you don't get shifts offered to you. So you're not really choosing your own hours. You're having to work them when the boss says, and if you don't, essentially they're terminating you, right? So the Digital Platform Act pretends like it's given digital app workers minimum wage, but it hasn't. What it said is you get minimum wage as long as you're actually got a passenger in your car or there's hot food that you're delivering to somebody. That's the equivalent of saying to the cashier at the grocery store, I'll make sure that you have minimum wage as long as you're actually checking groceries out for somebody. But if you're just standing there, rearranging the magazines in the rack, cleaning the rack, like if you're not actually checking somebody out, you're not actually working at that point, so you don't get, paid, and we're not going to guarantee that it's minimum wage, right? That's clearly fundamentally unfair. It's clearly wrong, and it clearly doesn't account for the fact that like you have to be on the shift starting at 9 o'clock, you get your first call, you got to drive 10 minutes. If you were a taxi driver, you'd be paid for those 10 minutes, right? And then you take the thing out to here in Chapleau and in Sudbury, huge distances you have to drive, right? There and back should count, not just the time that you've got somebody in your car. So all of that is unfair. This act actually takes rights away from workers, and it also gives you a recurring pay period and payday. The app's supposed to tell you about how you get paid and how tips are distributed and all of those things. It's supposed to give you notice of why you're being removed from the platform, and says that you shouldn't be punished for doing anything. Yeah?
So I do have a question in this one. I know the answer, but for the purpose of the presentation, where would you put content creators? Because that's where I am. So I get paid through multiple different platforms there, but Google AdSense is one. X Corp pays me directly.
Yeah.
There's also Stripe, I think it's called.
Yeah.
And that's basically a tip thing where you can give me a tip and then it gets to my account.
Yeah.
So how would they go and classify?
Yeah, so in some cases you may be able to consider yourself to be an employee, but in most cases you would be an independent contractor, and you have made arrangements with these different platforms to monetize the content that you're creating in exchange for putting ads on there, or just like any other business, you're saying, hey, if you like my business, tap the little thing and give me a tip, right? So in those cases, you are essentially an independent contractor. You are your own boss, creating your own content, and you have agreements through advertising revenue agreements or other agreements to get people to pay you directly through, a cash out system or through the advertising. There are interesting conversations to be had around the incessant need to be creating content in order to actually earn something through there, but that is an interesting conversation to have outside of this particular presentation. Any other questions around digital platform work? All right, temp agencies. A temp agency is a licensed business. In Ontario, you have to be licensed with the province in order to call yourself a temp agency that places assignment employees with a client company. So again, the temp agency is your boss and your employer. You might be working somewhere else, but they don't pay your wages. They give money to the temp agency and the temp agency pays your wages. Temp agencies are not legally allowed to ask you for fees for any part of their operation, for placing you within an agency, for listing you as a potential employee with their agency, for giving you things like, oh, you'd get more placements if your resume looked better. Why don't you take our resume writing course, or any of those kinds of things. The other red flag is, although they are not legally allowed to stop you from leaving their agency and being hired with the client agency, they will try and do that all the time, right? And so what happens is you're placed with an agency because, oh, the agency's like, oh, somebody's on a sick leave or a mat leave. We just want somebody for, 3 months, 6 months, 9 months, whatever we think it's going to be. And then they learn, oh, that person isn't coming back. Hey, wow, you're actually really good at this job. You're already here. You're already trained. Why don't we just hire you instead? The company is allowed to do that and end the relationship with the client agency. But the temp agency is going to make it very difficult for them to do that. They're going to put a lot of pressure on them and on you, which is all illegal, but they still try and do it. And a lot of questions arise around who's responsible for health and safety. So the changes were made in 2018 that make it very clear that both the employer agency and the client agency are responsible for health and safety, but there's still gaps in how that actually gets managed, and that creates a lot of problems for workers. Fun little fact in Ontario, in order to work, you need to be 14 years old to start off with basic work. You can be an independent contractor. You can be a babysitter, being your own boss, making your own charging your own rates before you're age 14-year-old. But before McDonald's can hire you to be at the cash, you need to be 14 years old. Before you can get that coveted fry cook position at Burger King, you've got to be 15 years old. You decide working for those food franchises is not the way you want to go, and you want to start working with your aunt who has a roofing company. In the summer times, you got to be 16 years old for that kind of construction work or logging work, and to enter into mining, to go underground, you got to be 18 years old. And those are set with the idea that we want our workers to have a little bit of knowledge, experience, and perhaps maturity before we start giving them knives and chainsaws and other things that might cause them to get hurt or that could cause injury to others. Now we're going to take a look at our basic rights, the exceptions and exemptions, and what reprisals are, what punishments are. So the Employment Standards Act sets out the basic rights for workers in the workplace, the minimum rights and general rules for wages, hours of work, breaks, leaves, vacations, holidays, and a few other things. Most workers are covered, but there are exceptions and exemptions. So obviously health and safety is the Occupational Health and Safety Act, but what about all those other things, your wages, your breaks, the Employment Standards Act, right? So who has some exceptions or some exemptions? So an exception means that there's a different rule for you, and an exemption means that that rule doesn't apply to you at all. So many professionals, lawyers, doctors, architects, nurses are exempted or have huge numbers of exceptions to the Employment Standards Act. Many EMS, healthcare, health professionals, manufacturing, constructing, and mining have different rules that apply to them. So in construction, you might have overtime rules that are the same, but depending on the kind of construction that you're doing, your overtime rules might be different. hospitality, services and sales, transportation, agriculture, growing, breeding, keeping and fishing, household, landscaping and residential building services, teachers and teaching students, co-op placement students, government employees and professionals, and there are some other industries and jobs as well that have exceptions or exemptions. So sometimes knowing the general rule isn't enough. You also have to make sure, are you actually covered by the general rule, or is there a different rule for you, or no rule at all? And today we are going to be looking at largely the general rules, but if you have a particular question because you work in healthcare or construction and you'd like to know what the rule is, I may be able to answer that today. If I can't answer it today off the top of my head, I will do the research and get you the answer immediately after this presentation or shortly after that. First thing the law says is you have the right to know that you have rights at work. So it used to be that this poster or a similar one needed to be placed in every single workplace so that workers could see it. But as part of the Getting Rid of Red Tape Act, when Doug Ford came into power, he decided that the red tape that was stopping businesses from thriving was having this posted once in the workplace. And so he said it no longer needs to be posted. Instead, it needs to be provided to each worker within 30 days, which seems to me like more red tape in work than just putting it up on a wall where people could see it once.
They'll shove it in your employment package and no one will even see it.
Exactly. But it is also illegal under the Employment Standards Act to punish a worker for asking about their basic rights, including hours, scheduling, wages, overtime, anything like that. Anything under the Health and Safety rules, Occupational Health and Safety Act, and you have a right to a workplace free from violence, harassment, and discrimination, and it is illegal to punish you for asking about any of those things or complaining that you're not receiving any of those things. So hurrah, because employment reprisals, so a punishment is called a reprisal. Because reprisals are illegal, we can just end this conversation because there'll be no problems in the workplace. Sadly, no. Employers will in fact punish you all the time for asking about your rights in the workplace. Examples, it could look like, in fact I'm just going to look at this slide. Reprisal can include termination, obviously, right? Reducing your hours, unfair scheduling, changes of work locations, drastic changes to work duties, and changes in attitude and dealing at the workplace. Let's look at wages and deductions. We have a general minimum wage of $17.60 an hour. We also have a student minimum wage of $16.60 an hour. So the word student can mean a lot of things. I was a student a few years back when I undertook my paralegal licensing. So when we say student, we mean a high school student, somebody who is under 18 years old, all right? Somebody that's working less than, and high school students are only allowed to work less than 28 hours a week. After that, they need to be paid the general minimum wage. So coming up this summer, a student who has been working, say at Tim Hortons, on the weekends, doing 16 hours, 2 full days on those weekends, will have been paid $16.60 an hour. If over the course of the summer they're asked to be working full time, the first 28 hours can be paid at the lower rate, and then after that they have to get the general minimum wage for them. And that's called a mixed rate. Mixed rates are legal. You can have other examples of mixed rates as well. We used to have a liquor server minimum wage, but it's now the same as the general minimum wage, and you still get to keep all of your tips. And there's also something called a home workers minimum wage, which is for people who have a boss, have deductions taken off of their work, their paychecks, have to report, work the hours their boss asks them to, et cetera, et cetera. They get $19.35 an hour. And the reason that their wage is higher is, when I left, not my house, but the place that I'm living right now this morning, we turned off all the lights, we made sure the heat or the aircon was off because we're not going to need it for the day, and we're not worried about whether or not our telecommunications package is going to be big enough to be able to, manage all the Zoom calls we're doing. But if I'm working at home, I got to pay extra heat, I got to pay extra electricity. I might have to have a slightly higher telecommunications package because I'm going to have all those Zoom calls or whatever. So those costs, which normally an employer would take care of, the law says you get a bigger wage so that all of that can go up. Minimum wage does increase every year based on the consumer price index. So similar to inflation, we get a raise every October 1st. Overtime is what everybody also wants to work as part of their wages. So overtime is not calculated on a daily basis. If you work more than 8 hours, it's not overtime. Overtime is calculated on a weekly basis on an average, all right? And you have to have worked 44 working hours in order to achieve overtime pay. Now, your particular boss or employer could put in a rule that gives you more than these minimums, right? There are certain companies that say, hey, anything after 8 o'clock at night is automatically overtime because we need people to work the evening shifts and it's hard to get people to work those evening shifts, so we're going to give you overtime, right? Premium pay for those times, being able to cover those shifts. So you can always do better than the Employment Standards Act as an employer. You can never do worse. Overtime is paid at the premium rate, 1.5 times your regular rate of pay. Employers should be averaging it on a weekly basis, but they can come to a written agreement with you to average it over 2 weeks, 3 weeks, up to a maximum of 6 weeks. Do you have to work overtime? No. In theory, your employer cannot ask you to work more than 8 hours in a day without you giving written consent. Or if you've got an agreed upon work hours, such as a 12-hour shift, right, then they can't ask you to work more than that. So in theory, you can refuse to work overtime unless there are exceptional circumstances. There was a big giant snowstorm, you were trapped at work, the other shift couldn't come, you had to work. Yes, you're going to get overtime for that, right? The reality is, though, that refusing overtime is going to make your boss unhappy. Although they shouldn't be punishing you for it, they might decide that they no longer want you in the workplace as a result of that. Reprisals, punishments often happen when workers refuse overtime on a frequent basis. But can you? Yes. Do you have the right to refuse it? The other thing that many employers will put in, if they know that overtime is going to be a big part of the job, is they will ask you to sign a contract, and that contract will indicate that overtime is part of the job and that you will be required to do overtime. In which case you have then entered into a written agreement with your boss that you will do overtime. And so then you can't refuse it because you've agreed to do it in advance. Yes?
Question.
Yeah.
Like I see some of them, it happens to some, and myself did before, but say they don't want to pay overtime, but you worked so many hours after, and then they'll hold that back for a day that you miss, or stuff like that. Is that?
It is legal under the Employment Standards Act. You and your employer should come to a written agreement about it. It's called time in lieu. All right. So instead of getting money for those hours, you're going to get the time off for those hours. It's still calculated at the premium rate. So for every hour that you work overtime, let's say you worked 3 hours overtime, so now you're going to get 4.5 hours of time off. And if the employer can't give that to you within 3 months, they're required to pay you the money instead.
Yeah, but what I see is, let's say you worked an extra hour.
Yeah.
And then accumulate to 8 hours.
Yeah.
Eventually, all you're gonna get is that 8 hours.
Yeah, so
But
it is
it's convenient too for the employee too, because okay, I missed a day. Oh, I got certain hours,
yeah,
but they don't get that time and a half.
it is absolutely a way that bad employers can certainly help, screw the workers out of money or time that they are owed. Absolutely, it is a thing that happens that bad bosses exploit that, don't give you the time off.
There's,
Yeah. So absolutely.
Yeah, just things that I hear, and some guys working extra time. Oh,
Yeah.
and which
Yeah, it happens.
it,
But again, if you believe that you've lost time and your boss hasn't paid you for it, you can file a claim with the Ministry of
Yeah,
Labor
yeah.
and
Yeah.
get that back. And we've helped people to do that with their employers. They ended up leaving that job or got terminated, and they were still owed a whole bunch of outstanding time in lieu that was never paid to them. And the ministry can order that the employer has to pay those hours to
go
you.
back when I first come to work in Canada. I came here in '59. I worked at 65. I worked for a GM dealership here at Chapleau. I didn't know nothing about overtime, getting paid overtime.
Yeah.
So I'd work all the hours that was available. One time, this guy comes in, and I was called in the office, and he kind of gave me a heck because I wasn't getting paid overtime. I said, well, back then, what's overtime?
Yeah.
And then, but anyway, so then the company had to pay me all the hours that I had overworked, but back then I didn't know what overtime was.
Yeah, lots of people don't know these things, right? Which is why I go around and do presentations like this so that people know their rights and know that they have these things. Sticking here with wages, you have to have a regular payday in your workplace. That is the law. It can be weekly, it can be every 2 weeks, it can be twice a month, which is different than every 2 weeks because some months have 5 weeks in them rather than 4. It could be once a month, it could be once every 6 months, right? Like, it doesn't matter what you and your boss agree to. It can't be skipped by the employer, and the employer also has to pay you in full on that day. So they can't say to you, oh, I didn't get paid by the client, so I'm just going to give you half of what I owe you. You'll get the other half later. No, that's not your problem. You did the work. You need to get the money. We can feel bad for bosses when they're in that situation, but they should also have a line of credit or some other thing to be able to pay you properly, right? The record of payment, and you must always get a record of payment with every single pay that you get, which indicates your name, the name of the employer, the pay period, and the date of pay, the hours that you worked, and each of the different rates that you worked. So maybe I do like a little bit more highly skilled work, and I did 20 hours of that at the higher rate of $30 an hour, but then I did like the low waged work of just like actually just transporting things around, and I did 25 hours or 24 hours at that, and so then I get 24 hours at that rate, and then one of those I worked an additional 2 hours at the lower rate, so I get overtime for that. So each of those, with the amount of hours that it is, has to be listed on the paycheck. And then the gross pay, all the deductions that are taken off, and the year-to-date totals should all be on there. And it should also list your vacation pay if it was paid out, or if it is accrued and they're just holding it, waiting for you to take your vacation. All of that should be on there. And the only legal deductions that an employer is allowed to take off are the statutory deductions that the government says has to come off, which are income tax, Canada Pension Plan, and employment insurance. If you're a member of a union, then union dues can be taken off. If you have a health plan, a dental plan, a pension plan, life insurance, an RRSP, something like that, which you have agreed to in the workplace, then that can be deducted from your paycheck. If you've decided you've got a United Way in your area and you decided that you wanted to donate some money to United Way through the workplace donation plan, which is a great way to help support things in your community, then that can come off. And of course, if the courts have ordered money to be deducted off of your paycheck, then that will be there as well. You don't have to agree to that. All the others, the statutory deductions, you don't have to agree to or not, they just come off. All of the other deductions, you agree to when you join the union, you're agreeing to have those union wages, et cetera, taken off. Oh, you know what's not on here? Uniforms aren't on here. Uniforms are allowed to be deducted as well. We think that's wrong. I mean, you know, your boss should be paying you to wear the uniform, not making you pay for the uniform that you can't wear any other time. And bad bosses may try and take other things off of your paycheck, but it's all illegal. So broken work, faulty work, spoiled or rejected work, spillages. None of those, even if they're your fault, should come off of your paycheck, right? Now, can your employer discipline you in other ways, right? Like if I'm using the equipment wrong and, you know, I'm breaking things as a result, they can discipline me in other ways, but they can't take the money off of my paycheck, right? Broken tools, including vehicles. Again, even if it was my fault, right? I ran that red light, I caused the accident. My boss can discipline me in other ways, but they can't say, and you're paying for the vehicle, right?
He can fire you. He just can't make you pay for the vehicle.
Whatever discipline would be in keeping with your internal progressive disciplinary policy would be appropriate, absolutely. So it could be up to and including termination, for sure. Losses due to shoplifting, which includes, you know, dine and dash at a restaurant, and includes gas and go at a fueling station, mistakes in credit or debit card transactions. You know, it was the busy holiday rush. They purchased $100 worth of stuff. You put in $10. The client didn't say anything because they're like getting this giant discount. You know, your boss has other ways to recoup that money. And then shortages of the cash or lost property, unless you had sole control over the cash or the property. But even in those cases, although the Employment Standards Act says yes, the employer can deduct that from you, there's a lot of what's called common law, the decisions handed down by judges when there was a dispute over whether or not that was really fair, that would suggest that maybe your boss can't force you to pay that back.
A theft investigation.
Yeah, so come and talk to us or talk to the Minister of Labor or a lawyer if you're in that situation. Because although your boss is saying that you should pay it back, maybe there's circumstances where you shouldn't necessarily.
You see that on the restaurant. I noticed some of the waiters, they made a mistake.
Yeah.
And at the end of the day, they had to pay whatever that money was missing. They had to put that in out of their pocket.
Yeah.
See that?
Yeah, and that is technically illegal and becomes a little bit more complicated, especially in the older days when a lot of it was done by cash. I mean, if the cash is short, but you've got more money in your tips, did you just forget to put the cash in the till? Like, it becomes a more complicated question in those days. Certainly, they were not things I ever enjoyed when I was working as a server if the cash came up short, because it's like, well, I don't know, but did I maybe not put in $10?
You know, sometimes it's a mistake.
Yeah. And sometimes did somebody else steal something, but now I'm getting blamed for it.
Yeah, that's the thing, yeah.
Yeah, so all of those things. So we're going to take a look at hours, scheduling, and breaks here. This slide's also going to show a little bit of overtime on that as well. But it's really important to note that your employer only has to pay you for the time that you're actually at work, right? So if you're late for your shift, if you leave early, if you take too long a break, they can deduct that off of your paycheck. And one of the reasons that I like to talk about that is most of us get that if I show up, 15 minutes late for work because I slept in, we don't expect our boss to actually pay us. However, in our modern digital world, there's a whole lot of tools that tell us when we're working and when we're not working, which may not actually accurately reflect what we're actually doing at work. one of the first things that I did at the worker center was a bunch of call center workers came to us, and the issue that they were having is that they were being called in. They all had to sort of stand in front of their computers and have this big like pep talk. If you don't make the sales, we're going to terminate you. I don't know what the pep talk was really like, but I think that was part of it, right? Like,
I know what it's like.
yeah. And they couldn't sit down and log in until they'd had this sort of big pep talk kind of thing. Like they couldn't go to their computers.
But you're not paid if you're not logged in.
But you only got paid once you started being logged in, right? So you're getting this 10 to 20 minute bit of work, but they weren't actually being paid for it because they weren't logged in, right? And so that was illegal, and fortunately the employer resolved that when we sent them a letter.
It's
And
like the payroll thing literally tracks your login and out from your machine.
yeah, right? And so there are systems like that that can, you know, you might work in a very large retail kind of environment, a big giant chain environment, and you're working the cash. So again, it's only when you key into the cash that you're technically at work, but the break room is way at the other end. You're in a uniform, you're walking through those aisles, somebody's like, oh, I can't find the stuffed little things that I want to buy for my cute little grandkid. You can't say, I'm not going to help you, right? Because if you do, you're going to get reported, you'll be written up by your boss, right? So of course you're going to help that person find the thing. So now it looks like you arrived late, but you were working, right? So our modern systems can in fact chisel you out of these kinds of things. And so it's important to track those, try and have conversations with your boss about rectifying that. And that's a great place where unions can actually help out. So maybe you want to talk about unionizing in a place like that to get better systems put in place. In theory, unless you have an exception or an exemption, you can't work more than 13 hours in a day. So again, we often think, you know, work, the trope is Monday to Friday, 9 to 5. Well, lots of people actually work a 12-hour day. A 12-hour shift is not an uncommon shift for people to work. And 13 hours a day should be the maximum that you're working. Can you work more than that if you agree in writing with your boss? Should there be a penalty if you say, I don't want to work more than 13 hours? No, there should not. Will there be a penalty? Quite possibly, yes, right? So that's why we exist, to help people in these situations. You're also, again, general rule, you're supposed to have 11 consecutive hours off between shifts. Now again, if you work a regular schedule, this usually isn't a problem. Monday to Friday, 9 to 5, there's always going to be 8 hours between 5 o'clock and your next thing. But for people who work irregular shifts, this may actually be a problem. Your boss might schedule to midnight and then, you know, have scheduled to start at 8 a.m. the next day.
I've definitely done that. Got off at midnight, started at 8.
And again, there are certain industries where there are some exceptions or some exemptions, but the general rule is that is not permitted.
It's like your shift change when they're changing from night to day. They didn't give you that day off.
Yeah, there's all sorts of ways in which it happens. And again, you can also be asked to work what's called a split shift. This is the bane in the world of retail, especially if you're a key holder or a manager, and you've got like tiny little extra duties for an extra dime on your paycheck, where you're like gonna be opening it up. So you're asked to come in at 9 to get the store ready for opening at 10, right? And then to work until 1 or 2 o'clock, and then to go away again, but to do the close later on that day.
So they have to pay a minimum of 3 hours. Does that apply to like a call-in? Someone who's on call and gets called in?
It does, yes. So split shifts are legal, and there's no definition as to what the split is. Split shifts should happen in that 13 hours. And yes, we have what's called a 3-hour rule. So if you get called into work and you arrive at work and your boss is like, actually, I have no work for you today, go home, they still have to pay you a minimum of 3 hours. They can also ask you to do work that isn't your regular work, but that is reasonable work for 3 hours or a portion of it to, you know, they're gonna have to pay you anyway, so they can ask you to do something. So what might be reasonable work? Well, let's say my job is to saw stuff and cut stuff. Part of my job also involves lifting and carrying stuff from certain places, also involves doing inventory. So if my boss is just like, and cleaning up my work area, if my boss is like, yeah, go and clean and tidy the shop, sort some screws for 3 hours, like all of that kind of stuff, well, that's reasonable. It's stuff that I kind of do anyway. It's not what I really do, mostly. But it's
sometimes you gotta compromise.
exactly right. What would be unreasonable would be like, well, why don't you clean the bathrooms? It's like, no. Cleaning the bathrooms is never part of the work that I do, right? Like, so that would be unreasonable. So reasonable work, right? And yes, if you're on call and you are called in and you only have to do 30 minutes on that call in, you still get a minimum of 3 hours on the call in, all right? Minimum 3 hour call, minimum 3 hour rule. When the 3 hour rule was first put in place, there was a period. It's like if your shift is canceled within 48 hours under the Canada Labor Code, there is also, a reasonable period of time if your shift changes. The rule got changed. You actually have to arrive at work for the 3 hour rule to apply. That is the only rule we have around scheduling. There are no other rules around scheduling, and your boss doesn't have to give you the schedule a week in advance, 2 weeks in advance. They don't have to get your consent before making the schedule. They don't have to, unless you've got some other agreement with your boss in writing, they can schedule you outside of what you consider to be the norm or what you consider to have agreed to with your boss. So for example, it's not unusual for a student, at a college or university to say, listen, I'd love to work with you part-time, but these are my class times, like I can't work any of these shifts. And then the boss to suddenly be like, oh, I'm scheduling for these shifts. The worker to say, well, I told you I can't work those. I've got school there. And the boss is like, well, if you're not going to take my shifts, then I'm just going to let you go because these are the shifts I'm offering. And there's nothing to stop any of that unless you had a written agreement with your boss that they weren't going to schedule you in those ways, in which case they're now breaking a contract, right? So we have no other rules around scheduling. It is something that we would like to see put into the Employment Standards Act, some basic rules that would protect and give some guarantees to workers around schedules in the workplace. Oh, and the other question is, you get a break. Again, a lot of confusion around this because many workplaces put in place better than the Employment Standards Act minimum. But if you work 5 hours, you are entitled to a 30-minute work break. So in your typical Monday to Friday, 8-hour day, right? You get one 30-minute break, a meal break in that time period. You and your boss can agree that you'll take it in 2 15-minute halves if you would like.
That's how they do it.
But that's all you are entitled to, right? So it's not your 30-minute unpaid lunch break plus a coffee break in the morning plus a coffee break in the afternoon. It's just that 30-minute unpaid break. Again, if you've got a 12-hour shift, that's 2 5-hour periods with 2 meal breaks of 30 minutes each in that 12-hour day. It's unpaid. So 8-hour day, I'm getting paid 7.5 hours for the 8 hours that I'm at the office. 12-hour days, I'm getting paid 11 hours out of the full 12 hours that I'm there. Can I work instead of taking my break? Legally, no. Your boss is required to give you that 30-minute unpaid break, right? Like, you cannot work during that break. Your boss has to give it to you. If you do the work and your boss pays you quietly and you agree, that's fine, but legally both of you are now breaking the law, right? The other thing that happens quite common, again, often in the world of retail or another customer service facing place, is your boss is like, well, just take your break when there are no customers in the store, except there's never a time when there are no customers in the store, right? So you never really get your break. So you actually work the full kind of 8 hours, you sort of nibble some snacks in between, but you don't get that 30-minute break from work. And then at the end of the week, you take a look at your paycheck and you're like, listen, I worked 8 hours, but you only paid me for 7.5. Right? And often an automatic payroll system is just doing that.
So that is legal, just so you work, like say you work 8 hours.
Yeah.
So you only get paid 7.5 hours if you take that break?
If you take that meal break, yeah.
Oh, that is the law.
It's an unpaid meal break, yeah.
I didn't know. I thought that you work 8 hours, you're allowed a 15-minute break and.
That's what you're saying. Some employers will pay you for it, but they're just doing better than.
Oh.
Yeah, some employers do better than the
I
law.
didn't know that.
Yeah.
I thought that was just an automatic, you're allowed 15 minutes break on your 8 hours work.
No, 1 30-minute unpaid meal break. Yeah.
Oh, there you go.
Yeah. All right, we're gonna take a look at vacations
Still learning. Still learning.
Yeah. Well, and the laws also change over time, right? So
But
that is the
with
current.
this 13-hour work, like on trucking logbook, it was now most of the companies now they got the log. It's on a truck.
Yeah.
Yeah, and that is a good thing.
Yeah, and transportation has some special exemptions and exceptions to the rules.
Because, I know there was a lot of things, and
Yeah.
that probably still going on.
Yeah. Yeah.
I trucked for many years, and
Yeah.
my trucks, I had trucks that I hauled here. We didn't have, back then we had nothing like that, so that we just went by the book. But,
Yeah.
I know a lot of companies, drivers, their own companies that they cheat on the books and there was
Yeah.
nothing. That's why now all most of the trucks now they have it's on the truck. And I know a friend of mine, he's 78 years old and still trucking, and he says 15 minutes before your 13-hour you get a warning, so you gotta look for a place to pull over or else.
And there was recently a big report.
Yeah, it is.
Yeah.
That is a good thing.
Yeah, there was recently a big report as well on the trucking industry, and so it talked about companies that have built workarounds around these safety issues, and also the big problem is that many truck companies often tell the drivers that they are independent contractors, so they're not getting the deductions and things, but they don't actually. The drivers don't actually have the power to control
I wish
everything, right?
there was. I'd like to talk to the Department of Transport about a lot of the things that are going on. And, and they're catching on in some of them.
Yeah.
But there's stuff going on in there that should not.
Yeah.
We're not going to discuss that in here.
No, I mean the reality
Yeah.
the reality of all work is that we have seen a history of exploitation in work, right? Bosses have often tried to take advantage of workers to
Big
get
time.
pay them less, to put them in unsafe working conditions in order to get more out of the workers so that they can get profit while giving less to the workers, right? And that is what helped to drive the union movement, in the late 1800s through to the 1950s, that 100-year period where unions were at different times legal and illegal and have a great history of getting into place. And a lot of the protections that we take for granted in Employment Standards Act are the direct result of the fight of our grandparents and great-grandparents and great-great-great-grandparents in the union movements to put in place the rules and regulations that help us with health and safety, that help us with minimum entitlements, getting the weekend, right, thanks to the union movement, all of those things. So we know that bosses have a history of trying to exploit workers to make more money for themselves, right? And that's why we need to have these laws, and that's why I go around telling people about their rights. So when we're talking about vacation and holidays, so stat holidays are the single days that everybody or almost everybody gets to be able to take off, and vacations are that longer chunk of time that you get from your employer. And there's two connected but separate ideas, all right? So we have holiday and vacation time, and holiday and vacation pay. You always get the pay unless there's an exemption for you in a particular industry. You always get the pay. You may or may not be able to take the time, right? But the money always belongs to you, and that money comes out of your boss's pocket, not out of your pocket. So let's start with holidays. There are 9 statutory holidays in Ontario: New Year's, Family Day, Easter, Victoria Day, Canada Day, the August long weekend, Turkey Day, Christmas, and the Day of Boxes. So those are the 9. At the federal level, they have a couple of more. So Remembrance Day in November, the 21st, Day of Truth and Reconciliation, and then September 20th, I think, or 22nd, and then June 21st, Indigenous Persons Day, are also at the federal level. A provincial employer may decide to give you those days off as stat holidays as well, but they're not required to. So if you don't work on the holiday, right? If you're not working the statutory holiday, if you're one of the lucky people that doesn't actually have to go into work, then you get what's called holiday pay. Holiday pay is calculated as your last 4 weeks of pay that you received divided by, not 4, divided by 20. I don't know why it says 4 there. That number is wrong. I will correct that. Divided by 20. And if you work a regular 9-to-5 job, it works out to 1 single day's pay, right? If you have irregular pay in there, where you did a lot of overtime in the last little period, your holiday pay might be larger on that day. And the interesting thing about it is if you work part-time, and you don't actually normally work the day of that holiday, so let's just say many holidays fall on a Monday, right? Either by design. So let's say you only work with the company Tuesday, Wednesday, and Thursday, right? You work 12 hours a week, 3 4-hour shifts, 12 hours, right? So every week you get the same pay of 12 hours, except after the statutory holiday, which fell on the Monday, your paycheck's actually going to be higher because they're going to look at your last 4 weeks of work, divide that by 20, and give that pay to you for the holiday pay, even though you didn't actually work that day and you never work that day. And the interesting quirk is me that actually works full time, Monday to Friday, I didn't get paid my regular wages on that holiday. I got my holiday pay instead. So my paycheck is going to look exactly the same, which is one of those interesting quirks of how we do the law.
I know how that, I don't know where I hear that, but if you don't work the day before that holiday pay,
Yeah.
you don't get paid.
Yeah, so it's called the first and last rule.
Okay, so that's...
Yeah,
it's
it's
like
called
to
the first.
stop them from taking a longer vacation by missing one of their shifts.
Okay.
Yeah.
That way they don't get paid.
Yeah, so if you don't work the last scheduled shift before the holiday,
Right.
and you don't work the first scheduled shift after the holiday, which doesn't have to be a regular shift, you could have agreed with your boss that, like, you know, we're going to change the schedule here, this will be my last scheduled shift, and you don't have a good reason for having missed those shifts, then yes, you don't qualify for holiday pay. So let's say you got sick and you have a medical note, or you got in a car accident and you couldn't come to work, no fault of your own, and it ruined your long weekend, right? Like, you still got the holiday pay because you had a good reason for having missed that shift, right? So if you do work the holiday, because all sorts of people do have to work on a stat holiday, right? Like on Canada Day, I'm going to leave my house. I'm going to hop in a bus. Oh, so bus drivers are still working, right? I'm going to get off the bus. I'm going to go into the convenience store and buy myself some snacks. All right, the people at the convenience store are working. And then I come out and I trip and fall and I have to go to the hospital. Like, right, lots of people still have to work on a holiday, right? So if you do work on a holiday, you receive the holiday pay that you would have got if you weren't working, plus premium pay, 1.5 times your regular rate of pay for all of the hours that you work.
So 2.5 times now.
So a lot of people say, yes, it's like double time and a half because you're getting your holiday pay, your regular
Yeah,
thing.
it might not be depending on the length of the shift.
And some unionized workplaces or some employers may actually give you a premium rate that is higher than the minimums under the Employment Standards Act, right? So I have seen collective agreements that actually do say on a stat holiday, or if you're working called in to work on your vacation because we're short and so we'd like you to fill up some shifts on the vacation, in those instances we actually pay you the unionized premium rate of 2.5 times, right? So you might have a greater than entitlement because of a individual contract or a negotiated agreement that you have. You can also negotiate with your boss in writing that, listen, I'm just going to work on this stat holiday for my regular rate of pay, but instead I'd like a different day to be identified as my stat holiday. I'll take it off and you'll pay me holiday pay based on the formula for that day. So for example, maybe you're Jewish and you'd like to take Hanukkah entirely off and another day in December off, but you're perfectly fine working Christmas and Boxing Day. You don't care about those days, you're Jewish, right? So you agree with your boss, listen, I will work those days, my regular rate, you don't have to pay me extra, no premium pay, but I want to take Hanukkah and the day after Hanukkah off.
And get my holiday pay.
And I'll get my holiday pay on those days, right? You and your boss agree to that, that's perfectly fine. Vacations. So, in Ontario, the moment you start working for an employer, you start earning vacation pay. After you've worked with the employer for 1 full year, you are entitled to take vacation time. Within the first 5 years of your employment with the same employer, you get 2 weeks vacation. After 5 full years with the employer, you get 3 weeks vacation. It used to continue to grow. That rule has been taken away. So 3 weeks is now the maximum that you get under the Employment Standards Act. Your employer may give you greater entitlements, okay? The pay that you get with that is 4% of your regular wages within the first 5 years, and then 6% afterwards. Again, the math roughly works out that it works out to 1 week's worth of pay, or rather 2 weeks worth of pay. But again, it's 4% on each of the wages that you earned. If you earned a whole bunch of overtime, then you're getting also more vacation pay as a result of that. By default, the employer holds your vacation pay in trust, and then when you go on vacation, they pay it out to you before you go on vacation, so that you have the money to be able to actually take the trip that you're wanting to take if you're actually going away, right? Or you and your employer can agree that they're going to put the 4% or the 6% on every single paycheck. And if you're working a short-term contract, if you're a part-time employee, that might be the better way of doing it, right? If you work irregular shifts, then that might make more sense. Listen, you're only working with me for a 1-year contract. You're never gonna get into that second year when you're allowed to take the vacation. I just wanna put the 4% on every single paycheck so that when you actually leave, I don't have to suddenly give you a big chunk of money. I'd rather have the pain be lesser for me as the employer, right? And also, you work part-time. Are you on the schedule or are you on vacation? I don't know. I don't want to have to think about it. I'm just going to put 4% on every check, right? And if your employment ends, whether you quit, you were terminated, doesn't matter, your employer has 7 days or until the next pay period, whichever is greater, to pay you out any unpaid vacation pay that you might be owed. Okay? Any questions on that? Let's talk about leaves. So, the 3 main and general job protected leaves that people think about are sick leave, family responsibility leave, and bereavement leave. Sick leave is when you're sick. And the Employment Standards Act has a very small amount. You have 3 unpaid but protected sick days. So unpaid, obvious, you don't get any money for being sick on that day. Protected means your boss can't fire you for taking that day. All right? Do you have greater entitlements under the occupation or under the Human Rights Code of Ontario? You do, but under the ESA, 3 unpaid protected days. Family responsibility leave is also 3 unpaid days. Sick leave, I'm sick. Family responsibility leave, my 5-year-old is sick, I have to stay home to take care of them, right? Doesn't have to be a child, it can be any member of your family that requires you to be the primary caregiver for them, right? An aging parent, your twin brother who has gone into the hospital and you need to be there, all of those things count, right? Bereavement leave is because of the death of somebody in your family, and it's only 2 protected days unpaid. We think these numbers are way too small. We think they should be higher, and they should also be paid. Nobody should have to make the choice between going to work sick or paying their rent at the end of the day. And there's lots of excellent data out there that shows workers don't take advantage of paid sick days, and it's actually better for the business because there's less absenteeism. You know, if you're sick at work, you're not doing a good job, you're more likely to have an accident at work, and you're more likely to spread that illness to other people, and they then become less productive or take time off from the workplace. Yes, Allison?
Is there anything in the ESA that speaks to like who bereavement leave applies to?
Yes, there is a list in the Employment Standards Act that is essentially anybody that is 1 degree of family from you, so your parents, your children, your brothers and sisters, your aunts and uncles, and any of those by marriage or adoption as well, right? So an adopted parent, a stepchild, all of those things are included. So there is a list that the Employment Standards Act provides, which says all of these count. And again, your employer can be broader than that. But yes, it does mean that your best friend for life, the person that you've been friends with since you met at age 2 years old in the daycare, that you do everything with, they are not covered under the bereavement leave.
And neither is your dog.
Neither is your dog. Yeah. And then we also, of course, have pregnancy leave and parental leave. So pregnancy leave is just for the mother that's giving birth. Adopted mothers do not get pregnancy leave. They are not actually pregnant. And parental leave is for anyone who's giving primary care to the child. So that obviously means a birth mother, it means an adopted mother, it can mean the father, it can mean the single-sex parent of an adopted child or family.
So there is a difference between a paternal leave and pregnancy leave.
Yeah, parental leave is anybody that's acting as the parent, being the primary caregiver for that. And again, it's the same sort of list, right? So spouse, you know, if my kid decides to have a child, I, as the grandfather, could be like, you know what? You've got a great job that earns a whole lot of money. Why don't you keep working? I'm going to take a parental leave. I will go on EI. You know, I don't really need the money because my wife is earning a lot. And so I'm going to go on EI and I will become the primary caregiver. That counts, right? And again, there's no pay from your employer for pregnancy or parental leave. It's protected but unpaid. However, you may qualify for employment insurance. We also have sexual or domestic violence leave in the Employment Standards Act. And if anybody is uncomfortable about thinking or talking about this, you're more than welcome to plug your ears or leave the room. We're not going to get into any gory details about it. But sexual or domestic violence leave applies to any worker who has received sexual or domestic violence or the threat of sexual or domestic violence, or whose child has experienced sexual or domestic violence or the threat of sexual or domestic violence. The first 5 days of this leave are paid and protected. They enable you to do things like have to deal with the criminal justice system, have to deal with finding a new house for yourself, new shelter for yourself in the case of domestic violence, deal with the healthcare system, including, the physical things that you might need to do, as well as mental health care that might be part of that. And then the additional weeks of 10 and 15 weeks are unpaid but protected. And they, again, the criminal justice system, the family court system, moving to a new home after having exited a shelter, all of these might require some time, and you are not penalized for taking that time off of work. It's unpaid, but at least you don't have to make a choice between going to court or losing your job. Termination. Anybody can quit their job at any time in Ontario. If you have a written contract that says you are required to give a certain amount of notice, then you are required to give that certain amount of notice. If you do not have a contract, a written agreement with your employer that says you have to give a certain amount of notice, there is no requirement under the Employment Standards Act to give notice. Is it customary to give at least a week or 2 weeks? Yes, but are you required to without a written agreement? No. Not every quitting is voluntary, but if it truly is a voluntary termination, you get nothing for quitting your job. Your boss owes you nothing, because the presumption is that you're quitting because you're deciding to go back to school, or you're deciding to go to a better job, or you're deciding to go and travel. You've built up a bunch of money and you're going to travel around the world for a little while and be an influencer on Instagram and tell everybody how fabulous your life is, or whatever it is, right? In Ontario, your boss can decide to end the employment relationship at any time. If you're within the first 3 months of employment, they don't have to give you any notice or pay in lieu of notice. After the first 3 months, they are required to give you notice or pay in lieu of notice for terminating your employment. The amount of pay or pay in lieu that you get depends on how long you've been working in the workplace. So after 3 months and up to 1 full year, it is 1 week of notice or pay in lieu of notice. After 1 full year, but less than 3 years, it's 2 weeks of pay or notice. After 3 full years, 3 weeks, 4 full years, 4 weeks. You're seeing the pattern. It caps out at 8 weeks, all right? Termination pay in lieu of notice is this idea that, if you knew your job was coming to an end, if your boss said, hey, Megan, really sorry, it's been great having you, but we're going to be, closing this operation down. You've worked with us for 2 years, but I'm going to give you 4 weeks notice, right? If you knew that in 4 weeks you were going to be out of a job, you'd start looking for a job, right? And so if your boss is like, hey, I'm ending your job now, don't come back after today, that pay in lieu of notice is to help cover your bills so that maybe you can try and find a job in 2 weeks, right? In Ontario, we also have something called severance pay. Severance pay only goes to certain workers. You have to have been with the employer for more than 5 years. The employer has to be a fairly large employer, having a payroll of $2.5 million or more. And then there's a few other rules, like, have they also terminated a bunch of people recently, so now maybe their payroll is less, but you still qualify because, recently they had more than that, right? And you get 1 week of pay for every year or part year that you worked up to a maximum of 26 weeks. And you can still get termination notice or pay in lieu of notice and severance pay. They stack, all right? In some cases, your employer can say, actually, under the Employment Standards Act, I don't need to give you any pay or pay in lieu of notice because you engaged in willful misconduct. you did something bad and you knew that what you were doing was bad, you were disobedient, I told you not to do those things and you kept doing them, and that disobedience generally has to be not trivial, it has to have caused a problem, or you were negligent in a manner that was not trivial and was not condoned by the employer, right? So, hey, you didn't shut off the lights, I'm going to terminate you with cause. Well, did actually any harm happen from not turning off the lights, or was that trivial, right? And then also, why are you punishing me? Almost nobody turns off the lights. Like, you clearly don't make this a big issue because you've never punished anybody else for not turning off the lights, right? So you've actually allowed people to think it's not a problem if the lights aren't turned off at the end of the day, right? So if it's one of those things, then yes, they can terminate you without giving you notice or pay in lieu of notice. The bar is pretty high for proving those things. So if your boss is saying they're firing you with cause and they don't have to give you anything, please come and see us or speak to another legal professional who can help you understand whether or not it actually is going to meet that. When you end your employment, no matter how you leave, whether you quit, whether you were terminated, your employer is required to provide a record of employment to Service Canada, which tells Service Canada whether or not you are able to get employment insurance. It used to be that you would actually get a physical paper copy. Almost nobody gets physical paper copies. It will be submitted directly to Service Canada. You don't need to receive your ROE or even to know that it's being issued in order to apply for employment insurance. In fact, Service Canada says, don't wait. Did you get terminated today? Apply tomorrow, right? So apply immediately for employment insurance. So that is sort of the end of the Employment Standards Act. I am going to quickly talk a little bit about violence, harassment, and discrimination in the workplace. So both the Occupational Health and Safety Act and the Human Rights Code of Ontario prevent violence, harassment, and discrimination in the workplace. You have a right to feel safe and accepted at work. If you believe that there is an issue in the workplace and you file a claim, employers have a duty to investigate. And if you require an accommodation in the workplace for reasons of disability or family responsibility or creed or any of the other 17 protected codes, your employer have a duty to provide reasonable accommodation up to the point of undue hardship. And these are big things that happen in the workplace on a regular basis, which is why I touch on them just briefly in our presentation about your basic rights in the workplace. And how do you know if it's health and safety or if it's human rights code? So it's a health and safety issue right up to the point that it becomes a human rights issue, right? It can be both. If I, as a boss, I'm just abusing you all in a general way, you're idiots, you're slugs, you're stupid, you're small, my dead grandmother could do the job better than you, like any of those things, that's abuse, it's violence, it's harassment, but it's in a general way. However, if I start to make it about a protected ground under the Human Rights Code, age, race, color, ethnic origin, citizenship, country of origin, disability, creed, sex, gender expression, gender identity, any of those kinds of things, then it becomes a human rights issue. All right? Sexual harassment is any harassment in the workplace that is based around sex or gender. So it's not just being hit on or asked to have sex with the boss or a coworker or something like that. It can just be making fun of somebody because they're blonde in the workplace, right? Which we generally, teasing somebody, oh, aren't blondes supposed to be dumb and more sexual or those kinds of things? That is sexual harassment, right? Because it's based around sex, making fun of somebody because they are gender neutral, identify as being asexual, all of those things. All of that is sexual harassment in the workplace. There is free legal advice that you can get by calling 1-833-677-5146 to get free legal advice on these issues, and we're here to help. So we'll briefly just talk about filing claims. If something bad is happening in the workplace, the number one thing to do is to document everything. Keep a copy of everything. Your boss gave you a schedule, but you work different hours because somebody didn't show up, so you worked extra hours. You had to work an extra hour beyond your schedule because the job really, really needed to get done. Keep track of all of that information, right? Keep your pay stubs. Your boss shouldn't be asking you for medical notes for short term, for 1 days of illness, but if you did get one, keep a copy of it. Any injuries or accidents, health and safety issues, disputes and claims, anything your boss ever asks you to sign, make sure you get a copy of it or a picture of it. Keep all of those things. If somebody overheard something happened in the workplace, be like, hey, Mike, did you actually hear that? Did you see that? Try and do it in a written way as well. Send them a text message so that there's documentation. Somebody else saw this happen. Somebody else heard it happen. Somebody else was affected by this, right? And then the Ministry of Labor, you can file a claim for Employment Standards Act claims or health and safety claims with the Ministry of Labor. You have up to 2 years to file a claim. It's free to file a claim. Anybody can do it. You don't have to have hired a lawyer or a paralegal to do that. And that's something that I can help you with. And again, all our services are free. If it's a human rights issue, you have 1 year to file a claim. And maybe one day I'll come back and do a human rights one here. So that is the end. Here's how to get in touch with me, either through the legal clinic or the Worker Center. And does anybody have any questions that didn't get asked during the presentation? In that case, I have perfectly done my presentation in 90 minutes. It's a first. It's a first. I managed not to talk too much. So thank you, everybody.
Thanks for watching. Don't forget to like, share, and subscribe. If you have a story or event you would like to see featured on this channel, just send us an email at nocaudits@gmail.com.